Yeah, okay. So we can start by now and the others will join maybe a bit late. Uh, it's my pleasure to make this brief opening today for this very interesting webinar. As you might be aware, Georgia International Arbitration Center is organizing the GIAC Arbitration Days each year since 2014. And unfortunately, this year, due to the well-known reason, we were not able to organize the conference in person. So we decided to move in the virtual reality and to organize the so-called virtual GIAC arbitration days, which consist of the series of online events throughout November, December this year. And this event is also part of it. And it's a great opportunity for the young practitioners to get the insights about the first steps in the private practice of international arbitration. First of all, I would like to thank the panelists to be here and also to present them. So Rusa Tchkuaseli is a senior associate at BLC Law Office, which is one of the leading law offices in Georgia. She's a head of M&A, banking and finance practices, also actively in commercial arbitration and litigation. Rusa has an experience of acting counsel in several domestic as well as international arbitrations, including investment arbitration. She's also a member of the Georgian Association of Arbitrators and co-trainer of the accreditation program for the arbitrators, which was launched last year. And I also had the honor to be in the second module of that. Rusa is also an invited lecturer at the Free University of Georgia, where she teaches the course of international commercial arbitration. Michael Davar, who is a UK qualified lawyer working in the international dispute resolution team of the global law firm Squire Patton Boggs. He specializes on complex multi-jurisdictional commercial disputes. He has acted as a counsel across the globe in a wide range of commercial arbitration and litigation matters. Michael is described as a rising star in Legal 500 for the work of international arbitration, and his recent cases include oil and gas arbitration in CISG region, multi-party arbitration in the Middle East, and financial arbitrations, shipping arbitrations, trade-related arbitrations in Asia. So he has lots of arbitrations done. Two of his cases have set English legal precedent, which is very cool. And he is also co-author of a number of legal volumes. And finally, I would like to tell about the logistics. The attendees will have the opportunity to ask the questions to the panelists, and they can use the QA feature, which is down there. And at the end of the webinar, the questions will be answered by the panelists. So, Rusa, the floor is yours.
Thank you, David. Thank you very much for introduction. Thank you to the organizers of this event for inviting me to speak. And thank you to everyone who decided to tune in to listen. And I hope we'll have informative and useful 1 hour today. And let me just note that we have like incredible audience, like from many different jurisdictions, and which would not be possible had we not have coronavirus. So I would say that this is a silver lining of COVID pandemic, so to speak, to have like so many people from so many jurisdictions gathered here today for this webinar. Michael?
Yeah, absolutely. Exactly as Rusa said there. So thank you very much, David, for the very kind introduction. Thank you to GIAC for hosting another excellent arbitration days, and for Rusa for sharing the panel with me today, which I'm very excited to be sharing, and for everyone who's attending, which looks to be amazing. As David kindly explained, my name is Michael Davar. I work in the international arbitration team in Squire Patton Boggs, and specifically in their London office. Now, Squire Patton Boggs' international arbitration practice is really quite large. It's very global. It includes more than 140 practitioners across 20 countries with experience practicing before virtually every major international resolution body in the world. In fact, this year, our team was named the International Arbitration Group of the Year by Law 360. I'm not going to go through my own practice, as David has already very kindly gone through that quite in detail. But I'd just give a very quick overview as to what we're going to cover today, both Rusa and I. We're first going to do a quick introduction to international arbitration, which Rusa will be providing, and then maybe some additional thoughts by myself. Then I'll go through some steps that provide advantages into breaking into private practice arbitration, with again Rusa providing any comments following that. And finally, we'll go through the steps that provide advantages when you actually break into private practice international arbitration. And hopefully we'll give you some quite useful oversight and also practical steps that you can actually use now, so that you as young practitioners or students looking into the sphere and the field of international arbitration can actually use to break into that and then get ahead. So I'll pass that straight over to you, Rusa.
Sure. Thank you, Michael. Yes, well, since we anticipated quite a young audience for today's webinar, students and young practitioners, we thought it would be useful to start off with an introduction to international arbitration, at the risk of stating obvious. Well, arbitration is a private method of dispute resolution, which is consensual. Parties agree to arbitrate their dispute through arbitration agreement. And it is generally preferred over litigation, especially in cross-border disputes, where parties are reluctant to litigate their dispute in each other's jurisdictions. Also, I would say that the general preference in terms of cross-border disputes, the general preference to arbitration is very much caused by the ease of enforceability of the arbitral award, thanks to the New York Convention on Recognition and Enforcement of Foreign Arbitral Awards, which has 166 contracting states. Enforcement of the award in all these jurisdictions is incredibly easy and possible. And apart from that, arbitration provides a confidentiality arrangement that is not attainable in certain jurisdictions, such as Georgia, for instance, in litigation. And what I would flag as a major benefit of arbitration is the ability to choose the adjudicators, the ability of the parties to choose arbitrators, especially when the dispute relates to like very specific industry like aviation, insurance, or banking, where you really need that qualified adjudicator, and that is oftentimes not available in the courts, and that is definitely situation in Georgia. So it's like a brilliant opportunity for the parties to themselves select the adjudicators on their case. That increases the trust in the process, of course, and it also increases the quality of the final award. Length is something that is also often parties complain about how long it takes to arbitrate, but when you actually compare it to the litigation, it's nothing. For Georgia, for instance, in order to obtain like enforceable, final, binding court judgment, you need to litigate at least 4 or 5 years. And in my experience, cross-border arbitrations, commercial arbitrations take on average 2 years, and even less when we're talking about domestic arbitration. But what is really very characteristic to arbitration, and I think that is also very relevant to our today's discussion that we're having, right? Building career in arbitration. I think it's the uniformity of the legal framework, the unified legal framework of arbitration that is available across jurisdictions. Due to New York Convention in the first place, the convention sets out general framework and like these red lines and boundaries of arbitration. And then we have ancestral model law, which is suggested pattern of the domestic arbitration law, how the domestic law could look like. And actually 84 countries adopted ancestral model law. So when you as a practitioner hear that certain jurisdiction is a model law jurisdiction, you know, you can predict the mindset of the lawmaker and how the arbitration is regulated in that jurisdiction. And I think that feature of arbitration, that is this unified legal framework that opens door to greater opportunities, to inclusiveness in arbitration, it's also like diversity, not only from like gender point of view, all right, but also a regional point of view. Diversity, for instance, me as a Georgian lawyer, I'm just qualified in Georgian law, and I'm able to handle arbitration cases. Like currently I'm handling 3 commercial arbitrations. One is seated in Geneva, second is seated in Stockholm, and third one is seated in London. We have tribunals consisting of 3 arbitrators in all 3 cases, and none of the arbitrators actually is qualified in the law which they have to apply to the case. So it's really fascinating to see how arbitration, how blurry the jurisdictional boundaries are in arbitration. And when I was studying at the university and I didn't know about arbitration at all, I always thought myself that I would be locked in practice in Georgia only, which is quite terrifying, because Georgia is a tiny jurisdiction. It's a small country. A legal market is even smaller. So you always have this outward looking mindset to look for the opportunities outside your jurisdiction. And I think that's where arbitration is flexible to allow to pursue your career, not only in certain jurisdiction, but across jurisdictions. Michael, if you have anything to add to this?
Very little. That was really great, Rusa. Thank you very much. And I mean, just to reaffirm some of the things that you said. Obviously, arbitration. There's several different types of arbitration, different types of procedures, and so on. There's obviously treaty arbitration, where public law is involved, and there's commercial arbitration, where there's arbitration between individuals or companies and governments even, and it's a consensual process that's essentially agreed through a consensual agreement to deal with disputes under a certain mechanism, and that mechanism is obviously arbitration. And that mechanism allows you a lot more flexibility usually than court procedures, which are subject to specific set rules. In the UK, it's the court procedure rules. I'm sure in Georgia, it's similar rules that you have to abide by. It allows you a lot more flexibility, and it gives confidence to parties who are absolutely international in nature, whether they're from Hong Kong or India or Europe or America or wherever they may be from, to get involved in a process and an agreement where they know that there will be, or there should be at least, an independent body who will determine any dispute as between the parties, rather than potentially a court system that may not be so fair towards certain parties, while they would be certainly a little bit more fair to others. So I don't want to say too much more than that, but I thought that's an interesting point to add. And again, thank you very much, Rusa, for that really helpful introduction, and very useful and interesting. I think I'll just take it on then to the next point, where which I'm covering the steps that provide advantages to break into private practice arbitration. Now, before I start on this subtopic, it's worth pointing that out that, of course, I and Rusa have been involved in the industry for some time. It's not always simple to see the difficulties faced by those seeking to break into this industry. And I have personally found, seeing the incredible and intelligent talent of young practitioners entering into the field, that competition is really fierce. So to make this as practical and as useful as possible, I've asked those interns and young practitioners who I have personally worked with and who I have previously worked with on steps that they found most useful when seeking to break into private practice arbitration. And in doing so, I found that the answers fell essentially within two key categories, which I think have weathered the test of time in relation to almost any industry or matter or activity. Now, the first category is to understand why you want to practice and specialize in international arbitration. And then the second is to be proactive and take proactive steps. Now let's take each in turn. First, understand why you want to practice and specialize in international arbitration. Now this is critical for two reasons. First, it will make being proactive much easier because of course, if you know what you want to do, you're more likely to persevere until you get it. And second, and I think critically for current purposes, is that it will set you apart from other candidates. International arbitration is somewhat of a unique area of legal practice. It is filled with people who immerse themselves in the arbitral world. They read about it, they talk about it, they intellectualize it, they love the practice of it, and they love the theory of it, and you can tell. To give a real life example, a year or so ago, I interviewed an intern who later sat with me and worked with me for a number of months. The answers she gave during the interview were phenomenal. Of course, there was the typical answer because it's international and so on and so forth. But really, her answers focused on her interest in the field. She had read and dissected cases which she personally found interesting and where advocates in the SPB, so Squire Patton Boggs arbitration team, had made submissions. She had identified what she agreed with and what she did not agree with. She highlighted to us that she was not just looking for a job, but she was looking to pursue her interest. And for me, at least, it set her miles apart. Now, second, take proactive steps. From the informal survey I carried out, the following were the key practical steps that I thought were very helpful and could provide a good guide as to the actions you should be taking at this stage. First, understand what international arbitration is. Rusa very helpfully gave you a brief introduction, but read into the topic. Understand what international arbitration involves, the reasons why international arbitration may be chosen over litigation, the differences between ad hoc and institutional arbitration, the difference between treaty and commercial arbitrations, the theory that goes behind arbitration. And this, of course, will be essential for you to understand why you actually want to do international arbitration, which was the first category I discussed. And second, consider attending an arbitration academy. Arbitration academies are designed to be excellent introductions into international arbitration. Some examples are the Cologne Arbitration Academy, the Arbitration Academy in Paris, the Austrian Arbitration Academy, the Swiss Arbitration Academy. If you can do so, get in early. It'll allow you to understand the international arbitration process and the key concepts involved. It would also allow you to network early on, which brings me to my third point, network. International arbitration is a big industry, but a small community. The more you network, the more people you know, the more doors that can open for you. This will be important for your whole career, but it's a great way to break into the highly competitive industry as well. Fourth, and this is what I have been told here, is that if you're a foreign trained lawyer in the UK and the US, it's very helpful to get a master's in international arbitration. I personally have not obtained one, but I have to say that the most driven young practitioners I have seen have now completed a master's in international arbitration. And it wasn't so long ago that international arbitration wasn't available as an independent subject. But now there are excellent master's courses available from top universities. And this has set candidates apart, not just on developing and demonstrating an interest, but also the level of knowledge and therefore usefulness of a candidate brings to the table. It definitely opens doors. And if a full-time master's is not on the cards, there are part-time masters available. And one example is the Queen Mary University, to understand, offers a part-time master's in Paris. Fifth, keep up with international arbitration news and developments. This is really easy to do. Set aside a few hours a week to read up. There are many websites that provide useful updates on the developments in international arbitration. The GAR website is just one example. And this is a step that should be taken in any industry you are looking to break into. The small step will over time build up your knowledge and your ability to speak with authority on the topic. And sixth, and finally, before I hand this virtual mic back to Rusa, is really consider applying for international arbitration specialist internships. Squire Patton Boggs offers one. I know many firms do, including WilmerHale, White & Case, and so on. I now have personally had 5 interns who have sat with me for 4 to 6 months over the years. And it doesn't mean you'll get a job, but it gives huge benefits. Internships give you a real insight into how an international arbitration private practice team works. It allows you to build a network with actual international arbitration practitioners who may back you for a job or recommend you down the line. It allows you to work on real cases and get fully involved, from the legal to the strategic to the commercial considerations. It also opens opportunities to do more than you expect. I have recently, for example, co-authored an article with a former intern, which is now published in the Chartered Institute of Arbitrators academic journal. Finally, and depending on how proactive you are, and also how nice the people you work with are, you can develop a very helpful mentorship, which I think we all know can be extremely rewarding and beneficial. And I think that's probably enough practical steps for me. But there is another which I know Rusa will be discussing. So I'll hand the mic back over to Rusa.
Yeah, very interesting checklist, Michael, and I hope very, very useful. I just wanted to add one tip, one recommendation from my personal experience, and that is participating in moot court, arbitration moots. Moot court competitions in general, and arbitration moot, and one of the most famous arbitration moot is this moot competition. I myself participated in this moot back in 2009. It was a long time ago. And actually, the firm I work for right now, they sponsored the Georgian team for the Vismut. And my boss attended the public rehearsal that we had at that time. She liked my presentation and she offered me a job. And that's actually how I got in BLC. So apart from these, it's the moot competition, like arbitration moot is it's an educational project, right? It's like it is designed to for the students to get knowledge in arbitration. It develops your writing skills, it develops your advocacy skills, your presentation skills, but it is also a very good networking opportunity. As Michael was saying, networking is essential, and this allows you to show your capabilities to your friends, your peers, who will be your colleagues in the future, but also to partners at the law firm. And that's a really tangible job opportunity, actually, to participate, to excel, to show your abilities to larger audience. And oftentimes at such moot court competitions, judges or arbitrators are practicing lawyers, partners, senior associates. And I myself can say that BLC, the law office I work for, regularly recruits Vismut alumni. So that's a real opportunity to get a job at BLC. And I have to mention here that actually this year, for the first time, Georgian Association for Arbitrators is holding a moot competition, arbitration moot. Actually, David is a co-author of the case that will be published very soon, and I hope we have Georgian students present today. And I cannot recommend you enough to go ahead, register. The registration is open for the moot, and have this incredible moot experience, which is very, intense in a way, but it is also very rewarding at the same time. And what is fascinating about moot courts or arbitration moots is that you're actually allowed to make mistakes, and you learn on your own mistakes, which is something that we don't have that luxury in real life, right? So that's a good opportunity to develop your skills. And one other point that I would add, Michael, also is, and which might not be relevant from your perspective, given that you are a native speaker in English, But for those who, you know, have their first language other than like English, French, or Spanish, it is a very, I mean, I cannot imagine someone practicing in international arbitration without knowing English and knowing English on a professional level. So that is something that you have to work on from early years when you are at a law school, maybe. That's it from my side on that.
I mean, that's really, really great. And I think that's also a good point that I wouldn't have thought of, obviously, as someone who grew up in England,
Right.
to inform actually, absolutely. I think there's some key languages in international arbitration, and it's very important that you make sure that you're professional in them, because language, as you know, in law matters a lot. So let's just go on our third and final subtopic, which is steps that provide advantages when you start out in private practice in international arbitration. Now, again, based on both the informal survey I had taken and also my personal experience, I've broken this down into two subcategories, which I thought were very relevant here. The first, again, is be proactive. Read into the industry sectors and the legal specialisms that the partners and associates that you work with and the team you work with focus on. And just to give you an example on my personal experience, I remember when my first seat in my training contract, and in the UK you have seats in your training contracts, either 4 or 6 or 8. One of the partners who was working in my department just obtained a shipbuilding arbitration. Now, I had never had any experience with shipbuilding before. I didn't know what that entailed. I didn't know what the issues were, and so on. But I wanted to work on the case. It sounded very, very interesting. The partner was excellent. The associate who was working on it was also excellent, and I wanted to work with them, get the experience, and so on. And I asked, "Do you mind if I get onto the case?" And the partner was a little bit hesitant. Obviously, as a new, freshly trained trainee, they wanted maybe someone with a little more experience. So he said he would think about it. But what I did, and I think this is a good lesson, and I've personally found this very useful time and time again, is I read about shipbuilding. I read about the issues in shipbuilding disputes. I got a book on shipbuilding cases, and I read the relevant chapters, and I went back and I said, listen, I've read these books, I know these issues, let me get on the case and let me help. Immediately after that, he said yes. And I saw the arbitration from start to finish. That was my first ever arbitration. I was involved in the drafting the witness statements as a result, the disclosure, the document production process, the expert process, attending the hearing, working with the clients, and I was very junior. And it just shows the level of proactiveness that you can demonstrate will give the authority and the responsibility on you, because people will trust you more. People will trust that you'll go the extra step that's needed, and they can focus on maybe what they have as bigger tasks and bigger strategic thoughts and other cases that they may be working on. So again, be proactive when you start and when you work, and it's a lesson to really live by. And the second category, I think, is to give yourself the opportunity to actually add value. And to do so, I think I've highlighted 4 points. First is be on top of the law. This sounds easier than it is, but it is not that easy, and particularly if you are busy, but it is critical. Those in senior positions will know the law, but they may have forgotten finer details or not have had the chance to review recent updates. You will realize as you go up the kind of ladder or the chain of hierarchy in law firms that the more senior you get, the more you have on your plate. It's your job as a junior person to be getting on top of the law and pointing out to them what the law entails in the event that you can do so. And this will really set you apart and will no doubt allow you to add value where possible. Second, read up on the procedural matters relating to the particular arbitration and also generally. Procedural matters go hand in hand with the actual law, and understanding and knowing the rules of the game will give you a serious advantage. It will allow you to understand what is going on, but it will also allow you to have additional ammunition and tactics and that are potentially available in the particular matter you're working on. And again, giving you a chance to add value and therefore do more and better quality work and gain more responsibility. Third, take the time and do not be scared about asking detailed questions on the cases you are working on and why you are doing a specific piece of work. And when you do so, you'll be able to obtain an understanding of the wider strategic picture and the specifics of what you're being asked to do. This will no doubt allow you to generate better quality work, give you more responsibility, allow you to think laterally, add value in ways that your senior colleagues or other colleagues may not think about, because everyone has a slightly different thought process. And this gives you the boundaries and the basics for actually working to the best of your ability. And finally, and before I again hand the mic over to Rusa, is just take a break between receiving instructions and actually starting to work. This is a rule I asked the interns who work with me to always take, because it takes time to order your thoughts and to ensure that you have what you need, and then you can go back and ask further questions if things aren't certainly are fully clarified. The last thing you want to do is come back with a piece of work that hasn't actually been asked for or hasn't actually answered the question, particularly where people are likely to be working with tight deadlines. Again, it'll definitely give you an edge in international arbitration private practice. It will give you the ability to add value and generally just be able to advance your career and do better things as you go along. So I think that was all the points I wanted to mention, and I'll hand it over back to Rusa.
Thank you, Michael. The point about adding value, I think that's a very important and valuable insight. Especially from a client's perspective, because ultimately all of us lawyers, we're service providers, right? We're paid for the value that we create for the client, and understanding the motivation of the client will, assist us to generate more focused ideas, to understand what is actually the value that we can create for the client in arbitration or in any other case we actually serve the client. What is the value they are ready to pay for? And this could be, of course, successful outcome on particular dispute, but not necessarily only that. We can create value in many other ways, like leveraging a settlement, like successful and beneficial settlement for the client, or closing of some other project that could also be leveraged through like litigation or arbitration tactics, or simply buying time for the client. That also could be a value that we create for the client. And these, understanding the motivation of the client and what client really needs, helps you then to plan your strategy on the dispute in a correct manner, in a manner which will be appreciated by the client. That's what I wanted to add here. And also, I think it goes without saying that you have to be hardworking, but I still want to stress on it. And Michael, you said that although like it's there are many opportunities, there is a competition as well. It's an extremely competitive field, and unless you work very hard, it's really difficult to get into practice and build up your career. And apart from working hard, you also have to have this mindset of a learner. You have to learn from the senior colleagues, from your peers, from the opposing counsel. I myself learned a lot from the opposing counsels as well. You have to be open for criticism and constantly try to improve your skills, your abilities. And the other point that I wanted to add here is that when we're talking about career in arbitration, there is like two potential paths that we can choose, or both of them, right? One is counseling on particular dispute, act as a counsel, and the other one is act as an arbitrator. And most of the practitioners start off with counseling on arbitration cases. That's how we all start. But ultimately, and at certain point in our career, we get arbitration appointments, right? And for that to happen, you have to actually build your reputation by hard work, by networking, and etc. By many other ways, like publishing articles, networking, showing up at conferences, and etc. So that is something that I wanted to add, that you have to, in order to get appointments as an arbitrator, which will inevitably follow, you have to create your own brand, so to speak. You have to create your name as a good lawyer, as a lawyer that is familiar with arbitration. You have to associate your name to arbitration, and then those appointments will come along. So that's one career path that we all who practice in arbitration as a counsels today, ultimately we envisage that we will be appointed as arbitrators someday, but we have to do our homework for that. That's what I wanted to add on that point.
Okay, that's very great. Thanks, Rusa. And I think that's it from our side. I think we covered the three key elements of getting an edge in your initial practice in international arbitration. So, David, if you want to take it over, or if any questions are arising.
Well, there are two questions which came up. Well, one was about the internship opportunities, and maybe you can elaborate more. How can the students apply for internships, and whether it's possible at your law firms, for example, and how is it possible to apply, and what should they take into consideration during the internship application process? And the second question is about the LLM, whether the pursuing LLM in international arbitration can kind of elaborate and can start the practice in arbitration after the LLM, which you also talked about it, but how important is it to make a LLM in international law for pursuing arbitration, pursuing practice in international arbitration? These are the two questions. And there is also one more coming up. So it's to you, Michael. What are your thoughts on the recent authority on the conflict in Halbert against Chap? So this is case related. There's some practical reverberations.
Okay, if I take the internship one, and Rusa, if you want to take the LLM question. So the internship one, Squire Patton Boggs, as I said, offers internships. I know a lot of law firms do. I would recommend you looking at the websites of those law firms to find out what the requirements are and to go through the application process. There's no real easy route in. It's always an application process, in my experience at least, where you have a written submission that you make and potentially answer a few questions, and then you go through either one or two interview rounds following that. It's very much worthwhile doing, but I do have to say the international arbitration internships are probably more competitive than you would expect. There are really very, very intelligent, really dedicated people to internet who have involved themselves in international arbitration in a huge amount before they apply for the international arbitration internships, and the level of knowledge they have on the topic is quite significant. So if I could give any recommendations, I would give those I've already given during the talk. Read up about it, know the news about it, understand why you want to do it, get some background information if you can, for example, through a master's or arbitration academies, or as Rusa said, through a moot, and then get that background information and experience, and then apply to an internship. I would, at least in my firm, it's unlikely you will get an internship if you haven't had any experience whatsoever in any form of international arbitration, including studying, unless you're some form of genius and have already read about it yourself and know all the rules, etc., and all the law that's involved. Yeah, just take those steps before you do so, so you can actually represent yourself in a very good way to those who interview you. And also you can add value when you're actually there, because you'll be focusing on international arbitration, nothing else really, sometimes litigation.
So I'll take the question about the LLM. As I understand the question to be, the question is whether if you're doing your LLM in international law, whether you can pursue your career in arbitration. And I think that is absolutely possible. When we're talking about international arbitration, commercial or investment arbitration, that is obviously a procedure, right? And you also need to have a certain basis on the material law that is used and applied. So you have to have an understanding of the material law that is applied to the merits. With respect to international law, I think that is very relevant for investment arbitrations, where international law is a part of the investment dispute, and the treaties that under which the investment arbitrations are carried out are obviously part of international law. So I think that experience is helpful. I have several friends who have LLM in international law, but with a twist that is investment arbitration and the WTO and other dispute settlement mechanisms that are relevant in international law. So having that experience, I think it will be useful for in practice, and you can practice as counsel in arbitration, mostly in investment disputes.
I agree with what Rusa was saying. Just to add on there a bit as well, is if you're doing international law, I assume you're going to also do conflicts of law. Conflicts of law are exceptionally helpful for international arbitration. It's almost fundamental that you know about conflicts of law when you do international arbitration, whether commercial or otherwise, or investment treaty or so on. So that's of course, it'll be very helpful, exactly as Rusa said, when trying to pursue international arbitration later down the line, and generally in your practice of international law as it goes. So
interesting, indeed.
Yes, and yeah, we have like one more coming up. It's about the languages other than English. So maybe which are the most used languages in arbitration other than English. So maybe likewise, Davar, maybe someone can study other language if he knows English or it's mother language.
yeah, well, I mean, Chinese will be probably a big language that is, or Mandarin really, will be a big language that develops. Russian is, there's quite a lot of arbitrations which are held in Russian. I've seen a lot in French, as Rusa said, as well, actually. So yeah, there are others that you can study, but English is a very big one. London is a top seat for international arbitration. A lot of international arbitration practitioners will speak English, and a lot of parties will appoint counsel that speak English and are likely to argue that they would want the arbitration to be held in English, and particularly because in a number of cases, your witnesses will be from all around the world. And one of the things that tie them together is a global language, potentially. So English is a global language, and that obviously helps. So there are other languages, of course, but English is a big one. So it's always recommendable to, I guess, learn that language in a professional capacity, as Rusa has very wisely suggested.
Okay, I think we're done here. Many thanks for the panelists for this work.
David, I think we have one more. I think we have one more question about.
Question and answer, you mean?
Yeah, I think it's in the chat that I'm reading. Okay. About saying that how can you get into a law firm where the law firms usually require experience for you to get in the first place. So I think that's a very valid question, I would say. At least in Georgia, like everyone asks for the experience for you to get in, but you can't have experience without getting in the first place. But what I can say from the law firm that I work for and the culture and the philosophy we have there at BLC is that we do not, for internship or like junior position, we don't usually ask for the experience, the actual experience. It's just a sufficient education and general practice. Like when we're talking about arbitration, having V-smooth experience, for instance, is valuable for us. And we already know that if student has done a V-smooth competition, then student is, proficient in English language, has certain basic writing skills and etc. And that's enough for us, of course, together with the other merits that student, you would expect student to have, that is sufficient to get an internship at BLC. And we usually have call every year or twice a year for the internships. I don't know how it works in your law firm, Michael.
Yeah, I mean, exactly as Rusa said, and also all the advice we've given during these during this seminar or talk, really, there are steps you can take to get experience without actually working in a law firm. A moot, international arbitration academies, masters, reading up, writing articles. There is also, in the UK at least, there's work experience applications you can make, which has 1 or 2 weeks in a law firm. That's the typical route that a lot of people get. There is also paralegal work, where you can work as in law firms and for dispute departments, where you get, I guess, the basic experience, and therefore demonstrate and get some of the information that you need going down the line. And paralegals will do some research work, some bundling, etc., and so on. Internships, of course, is another one. There are ways you can do that, and I would say experience is not limited to law. You can go and get another job first and then go into law. For example, myself, whilst I was in university, I worked as an FX and fixed income trader for a hedge fund during my 3rd year in university. And that has been exceptionally helpful for understanding how the world works, how trade works, and general financial background as well. And that's been really helpful, and I think did set me apart, at least sometimes, and some of the when I was trying to start out, because it shows your level of information that you have. And just one final point, because I think Tamar I don't know how to say, I'm sorry, your last name, Tamar. You said, do you see any practical reverberations in relation to Halliburton versus Chubb? And absolutely. So obviously, what governs the the arbitration agreement will determine whether or not it's valid or otherwise, potentially what formalities you have to comply with to make sure that it is valid and potentially enforceable down the line. So absolutely, it does make a difference. Parties will now know that, at least in England, and as, if you're subject to English law, or at least if you're subject to English law in terms of determining what the law of the arbitration agreement is, then you will know what law that will be, and that will be the substantive law. And then you can then use that to question the validity or otherwise of the actual arbitration agreement, which is, of course, very useful. For example, in the UK and in England, you can get the benefit for an English arbitration agreement which is valid, or an arbitration agreement full stop which is valid, to get an anti-suit injunction to stop court proceedings occurring outside into another jurisdiction in breach of that arbitration agreement. So the key question of validity of an arbitration agreement is fundamental. This judgment sets the very important precedent, at least under English law, as to what will govern, in terms of what law will govern the international arbitration or arbitration agreement. So in terms of practical reverberations, it has quite significant ones. And it does change the law from what it used to be, or at least clarify what it used to be, because typically you would, and from prior cases, the precedent was that the seat would be, I guess, the presumed, govern the presumed law of the arbitration, if no express agreement was placed within the arbitration agreement itself, which, by the way, I've very rarely seen anyone place the actual law of the arbitration agreement within the arbitration agreement itself. So very much so, quite a lot of practical importance that. But I think that was it.
Okay, thank you very much for this very interesting webinar. And I would like to say that it was also recorded, and the ones who were not able to attend it will have the opportunity to watch the recording online via our social networks, LinkedIn or Facebook, or maybe YouTube too. Many thanks for the attendees and to panelists, and keeping health, keep safe, and have a great evening ahead. Bye. Thank you.
Thank you very much.
everyone.
Thanks,
Stay
David. Thanks, Rusa. Bye, everyone.
Bye, Michael. Thank you.